Yes, thank you so much. I can be very brief, in fact. I'm pleased to have the pleasure to chair this first panel. And it's a great privilege for me to be doing so because I'm not a company lawyer. And so I feel really honored to be sitting in front of a bunch of the most brilliant minds in company law. And in fact, as Chris just explained, Tobias Ponsen cannot make it, which is a pity because he just published a really nice book on their Menschenvorbehalt. So that's kind of, what is it in English? Reservation of human actors, or what is the good translation? I don't know. But anyway, we have two great speakers.
Präconditio humana.
Oh, yes. Thank you so much. Yes, indeed. So it's now my privilege. I don't have to introduce Todd because he just spoke. But it's a great privilege to introduce Professor Schanze, and it's really an honor to have him here. He has been professor and director of the Institute of Comparative Law in Marburg, but he's had so many positions that I could spend the rest of the day listing them. I mean, he's been dean and a member of the Senate, but he's held professorships all around the world. I'm not going to give you the list of wonderful universities from Amsterdam to Wuhan and Nanjing. So it's from A to not Z. I think something with Z is missing. And Harvard and Columbia and everything in Yale in between. And so his academic focus is complex contract, corporate law, international investment law, dispute resolution. He's been working for, amongst others, the UNCTC, the OECD, the Harvard Institute for International Development, and others. And he has a list of impressive academic honors, including the Jens Westergaard Scholarship at Harvard Law School, the Walter Kolb Memorial Prize of the City of Frankfurt am Main, an honorary doctorate from the University of St. Gallen, and he's also honorary professor at the Faculty of Law of Nanjing University of Finance and Economics. And today, he's going to speak about demystifying corporate law, the person, the group, the franchise, and the problem of enterprise administration. Erich, the floor is yours.
Thank you very much, Christian, for this very kind introduction. My mother would be proud to hear this. I probably go on. You see this smoke on the water, high in the sky. So I try to do that. If I operate this, can you show me where it wants it? I should mention regarding Todd's wonderful presentation, if you go to my favorite place in Vienna, but probably one of the most beautiful places in the world, the Kunsthistorisches Institut, you find the portrait of Maximilian I by Dürer. And it's a stunning picture. You stand there, you look, and you are simply stunned. But there's also a text, and the text is Maximus Potentissimus, and that's what I apply, of course, to Todd Hensel. Maximus Potentissimus. He starts this introduction of Maximilian, Maximus Potentissimus. You understand that probably because you all speak Latin fluently. Okay. But Maximus Potentissimus. I should say that the Maximus Potentissimus talked about boards, and boards are, of course, a peculiarity of American law, which you don't find elsewhere in that kind of format. I mean, there's an Aufsichtsrat, of course, a different kind of institution, but I should mention that if I talk about directors, I talk about directors and officers. That means really about the management function, because you can't separate it. In terms of comparative law, you have to be very careful if you talk about these terms. I only want to mention that Todd's theory partly refers in the construction of the American board, which is a very special composition, has a special history, and has to take it on its own account. But it has, of course, to do with directors and officers. But I think basically we have to talk about the incorporation of directors and officers, because that's what he's really meaning. He talks about the administrative function, and my paper is about the incorporation of the administrative function. That's even a wilder topic, of course, in fact. So, okay, so the motivation of my talk is that legal narratives and associated pictures underlying conventional legal concept of enterprise organization are outdated and largely misleading. So I share basically Todd's point. And it's a sequel of a paper which I also gave here in Vienna. Today, the natural group shareholder idea is largely a matter of corporate finance. I'll put it in very blunt terms. We talk about single shareholders. What does single shareholder mean? I mean, who's a single shareholder? We talk about one-person companies. What's a one-person company? I mean, senseless terms, but they reflect realities. And we have to take these realities seriously, and we have to be honest. I hope you all understand me. We, of course, have a low pitch, and I hope that the microphone works. So should I put it lower?
You're just fine.
It's just fine. So we are basically, if we talk about Gesellschaftsrecht, we talk about dinners for one. I mean, it's more or less a nightmare what we talk about. And it's an inflated project. The whole project of Gesellschaftsrecht, in my view, has to be criticized. And I'm very happy that Todd pressed the reset button at this point. We need to press a reset button. That's my point of my talk. I don't want to read Hans Kelsen here. I mean, the natural person and the juridic person are not realities, they are legal constructs. And it was up to Chris, he said, if you come to Vienna, you have to cite, because you're talking about that all the time, you have to cite Kelsen. But Kelsen is absolutely right. Understanding the juridic person as a individual organism is a naive hypothesis. So this is probably absolutely correct, and this was written in 1934. No, finished obviously. Baylis Manning, one of the smartest lawyers of the 20th century probably, has written the following: corporation law as a field of intellectual effort is dead in the United States, and I would say elsewhere. When American law ceased to take corporation law as a group of natural persons engaged in a venture seriously, the entire body of law slowly perforated and rotted away. We have nothing left but our great empty corporation statues, towering skyscrapers of rusted girders internally welded together, containing nothing but wind. Now, that's a very rough point, but it's probably correct. I mean, if you take it seriously, if I read the Harvard Law Forum on Corporate Governance, it's mostly nonsense. I mean, what I read there is repetitious and nonsense, and I find it quite amusing, sometimes amusing. But if you hear all these stories about proxy voting and so forth, I mean, it's basically meaningless if you look at the reality of the Musks and the people who were cited by Todd. So we have to be honest and we have to be serious about things. And we can't go in this Harvard corporate governance operation any further. I mean, it's finished. So we have to press the reset button. Okay, I'm probably constantly operating this. Now, what I will talk about is some facts about enterprise organization. I've already said something. I will take two approaches. I will discuss shortly two approaches to the Bainbridge and Henderson proposal. And then I will look at the D&O function. That means that directors and officers combined in conventional firms and in franchising. And then I will look at franchising and look that it's already present, how we buy direction, and that we are concerned, probably if we talk about this matter, we are concerned with a limited liability cuckoo. limited liability doesn't really matter so much as we as lawyers assume it. I mean, if I look in the practice, and I've been long in practice in consulting, limited liability is not so important as lawyers assume. So we have to talk about, probably we have to talk about a shift in enterprise organization. Now, incorporated entities today do not have a necessary personal content. Special purpose vehicles are around. The standard group architecture of normal business undertaking contains typically incorporated property items. Within these satellite entities, no meaningful decision-making takes place. So if we form boards at that point, it's basically sham boards, boards which do not have any meaningful decision-making capacity. Here, both shareholdership and directorship have become pure fictions. For purposes of legal compliance, we see routines of staging pro forma personal decision-making events and documentation. We cannot expect any meaningful control from the inside of corporations, which is still the hallmark of a typical Gesellschaftsrechtsvorlesung. Hence, serious regulation must be addressed from the outside. And I'm very happy that Todd tackled. I didn't know that Todd would come to that topic, that we need control from the outside. If we want to make any serious impact, we are not very well served if we only think of internal control happening within corporations. There are two approaches to boards as what the Bainbridge-Henderson proposal. You can look at the law, written law, and it's mainly, of course, written now, not case law, but case law matters much more than we would assume in this field. I should say that. I mean, we usually get notices about the written law in the corporate charters, not the corporate charters, but rather in the corporate laws. And you can develop policy arguments. That was the argument basically of Todd's. Supporting these by comparative analysis. Do we have an explicit authorization of serious neighboring jurisdictions tackling with matching business environments? If so, if there's one jurisdiction allowing it, the other doesn't allow it, you will have a competition between these regimes. So this is typically what I would, as an economist, would expect would be happening. So that's one approach, which we will see today, and it's a very important approach, of course, to looking at the norms which are existing and makes sense. There's another approach, and that's these are a couple of friends whom I met by chance because I'm a very old man. Armin Elkin, one of the smartest people in the world. I've never met such a smart person. Only few. I mean Posner and others, but Elkin was really a super smart guy. And of course, Ronald Coase, whom I met in Chicago. There is a high likelihood that efficient institutions do exist in practice. That's what Coase says. They are produced and maintained in the process of institutional survival and Coasean bargaining. So if Todd's and Bainbridge's proposal makes sense, I would expect that it exists in practice without authorization. So that's basically the step I'm taking. So my program is this morning to look for the relevant implicit institutionalization qualified by something which I've written about, which is published in a number of texts, the hare and hedgehog paradigm. The hare and hedgehog paradigm refers to the fact that we always see circumventions. And sometimes judges and administrative officers acknowledge circumvention. That's what I observe. And the interesting, why do they do that? Because the circumventions may be Pareto superior. And that's what you find in franchising. Because in franchising, you have, of course, the cases of incorporated boards already present. So I will discuss a little bit franchising and my work in franchising, because I worked 10 years in that field in franchising, because it's a fascinating field, an alternative to corporate organization. Obviously, long-term contracts in franchising and corporate governance are closely linked together, because you simply use the tools which you find in the toolbox for creating new institutions. That's basically my work. If we talk about complex contracting, it's basically using the complete toolbox which is available, and there you make some headway in technical terms. Business franchising in the European sense, that's not Todd's vision of franchising. In the United States has a very broad meaning. You also have dealerships as franchises, called franchises. Germany, in Europe, the connotation of franchising is narrower, slightly. It means splitting up the administrative talks in a cross-principal agent relationship. And if you look at the Bainbridge and Henderson proposal, they discuss the case in which standard administrative qualities are required. That's the Cosian case, as he mentioned, of the firm in which direction is the central feature. As a legal matter, we observe factually largely irrelevant statutory provisions and mandatory rules on director independence, like Section 76. But there is no corresponding rule, and that's the cleverness of German law in the GmbH-Gesetz. So you typically use, if you want to have direction and you don't want to have the Article 76, you typically use the GmbH for circumventing that. So there's already a circumvention in the law, a circumvention possibility in the law. Let's only note. Now, if we look at the classical management function, that's what I'm discussing. It means directors and officers. You have an aggregation in the classic firm. The manager is responsible for innovation, tutoring, incremental upgrading, monitoring, and production. And that's all happening in the market procurement and market distribution scheme. That's the basic approach in a kind of standard setup of a management function. If you look in the function which you get in franchising, you have a split function. And the split function has, of course, feedback. That's not discussed in Todd's format. I think it's an interesting question that you have a conceptor of management function and you have a conceptee, somebody who realizes the function, somebody who conceives the function. I mean, think of McDonald's or think of anything which you know as franchise, which are quite successful. I'm not saying it's the most successful model. You have to make a choice. And we have in Germany, it's interesting, if you look at markets for hardware, we have both normal kind of industrial organization, that means administrative upsets which are using the GmbH scheme, and you have franchises. So you have both, and you can compare it, and you can look at the factors, what is cheaper, what is better. So there's a trade-off between the two models, which is really the Cosian kind of analysis of the matter. Okay, hiring a board, that's already mentioned this morning, is a make or buy decision. If the direct way of legalizing the staffing of director positions with legal persons is blocked by existing law or doctrine, adopting an incorporated franchisor as a factual director will offer a viable option for buying direction. So it's not simple, but it is viable. And you have to see that point if we discuss these matters. They're not only forbidding something or allowing something, but you have alternatives in the market. Now, I'm sorry. Franchising managerial service will, however, require a likely, in my view, even useful local component, the incorporated franchisee, who might be required to be staffed with a natural person as the director, if a natural person is the requirement of the existing law. So franchising, like incorporation, as such, or of boards, is open to abuse. And that's nicely discussed in the upcoming paper by Eva Micheler. The question of abuse by labor law, by tax evasion. Now, do we derive anything meaningful from the fact that things are incorporated? I would say no. You only derive criteria for a legal decision if you look in the tax law and the purpose of the tax law, or if you look in the purpose of the labor law. So you can only control it from the normative content of the counterpart. That's basically what I'm advancing since 50 years from starting with my dissertation 50 years ago. So the juridic person itself is a kitchen knife, and it can be used in many ways. It can be used to kill your stepmother or whoever, but it can also be used for doing ordinary things. And so the juridic person doesn't really have any kind of content which is inherently abusive or whatever, but it is probably a question of the outside normative environment which matters and which we have to deal in a very serious way. And this is why I'm very happy that Todd mentions the options looking at corporations from the outside. Okay. The relevant natural persons as directors are not completely immune from liability, but as I mentioned, and I will put that very short, we are entertaining a limited liability cuckoo, particularly among academics. Limited liability is not key for using the corporate format. Essential reasons for asset petitioning in the corporate format, and that supports Todd's idea, are a clean separation and definition of assets and of action rights and related delegation, enhancing accounting and auditing, including capital maintenance, and shielding, and that's probably the most important point, shielding the management function from personal incompetence and human frailty. Directors die, directors and officers die, and I mean, you have to give them a permanent meaning, and so incorporation may make sense. Asset partitioning by incorporation is one variant of asset petitioning. You can also form trusts and do other things, simply divide ownership. But it's a very successful variant of splitting up dedicated assets in action rights under the condition of absoluteness of the limited principle. And that is, in my view, not related to contract or tort differences. I would say we should either do it absolute or stop it. The incorporation partition variant includes the option for using it as a direction vehicle. So I endorse the idea of Bainbridge and Henderson, at least in the existing implicit variant of buying D&O services by franchise. In this way, I maintain we are already witnessing a global recognition of this institutional mechanism. So we don't have to fight too much. We might fight, but we don't have to fight too much. What does this mean? And this is now the first note or in passing from that. What does this mean for our understanding of enterprise administration in general? The incorporation variant of asset petitioning involves and underlines a fundamental structural shift of enterprise administration in our time. It reveals an involving basic institutional mechanism for resolving a qualified commons problem. You know what commons problems are, the problem treated by Harding, in the organizational structure of production of goods. And that already happened in the late 19th century. We didn't recognize this. For 1 century, we didn't recognize it, or didn't recognize it very well. But it happened already with the decision of Solomon. It happened with the decision of the Reichsgericht, acknowledging the one-man corporation or the one-person corporation as now modernly framed. I mean, used to be the one-man, and now has been. And so that's an old story. It's but we didn't recognize it in one century. And that's interesting intellectually, that we didn't really look at things very closely. We didn't recognize it. We finally introduced it, and it was very lamely introduced, but it was always there, with straw people founding corporations with sort of strange constructions, but we always said as if nothing happened. We didn't really recognize it. Now, recognizing the incorporation partition of ownership and control rights, like the earlier historical step of recognizing personal ownership as such, I mean, we cannot justify the fact that we have personal ownerships. I cannot justify why you own something or why I own something. It's very hard to justify if you think about it. So we also cannot really justify why we allow the partitioning variant in corporation. But it involves the next step of privatization of the legalized exclusion of other partial owners and their opportunities and risks. But it creates, in the process of institutional evolution, a more productive property rights structure with presumably more qualified hosts. That's what we hope if we allow that. And it's a very hard choice to do that, but it is a choice which has been taken. So we more or less underlined something which when I worked in this field, my basic headline was at that time, smart principles hire smarter agents. So that's a famous Schanze headline, which I used to begin. The true puzzle, and that's my final note, of advancing the idea onto the idea of incorporated boards is the matter of motivation. And we have to be careful. And that was really something which I got when I read Eva Michela's paper. Directors and officers' liability is a good example. Does law really motivate managers to work first creatively or diligently? Is law the essential factor? I would say lack of success and managerial mistakes are largely sanctioned by the market for managers. Discharge, loss of professional and societal recognition. That's basically the factor which really presses people to work as diligent as possible. They may be not competent. That's a big problem. The screening function may not have worked. We can't monitor them. So there is a very big economic problem with managers and also with the board members. You can't really truly monitor these guys. And the screening is difficult because it depends on many factors. So it's really the loss of reputation which matters most. And it's not the legal sanction of liability which matters for people who are sanctioned, even if they sit finally on castle like at Zumwinkel or anybody else. They're not happy because they have lost their friends and they have lost their reputation. And that's enough as a sanction. So we should not forget the secondary aspects of motivation. That's a triviality for economic modeling. So if I try to talk some into economic modeling, I usually say, well, please look at these functions too. Don't just use the institutional functions, which are evidence from laws also. And personal roles matter in agency relationships, hence the human factor matters. And I think this is maybe a justification why we still should keep the personal content in the board and direction function. It's a motivation problem. It's not a legal problem. Law would be flexible enough to do away with it. But there is this kind of tricky personal motivation problem. And this is the point where I'm ending. Thank you very much.